permit disclosures. They just added in a reference to section 553 here. Florida State made some changes to how permits can get closed out to make it a little bit easier to close out old permits. So they're just making reference to that here. We still need to add our permit language to the additional terms. Nothing has changed with that, unfortunately. Paragraph 11, they added a reference to paragraph 9A for escrow procedures. It's not new, they're clarifying, but a lot of people don't realize what it says in paragraph 9A. The seller is responsible for keeping the property in its as-is condition at the end of the inspection period. Paragraph 9A deals with what happens if after the inspection period, something happens to the property and the seller did not keep the property in the same condition as it was at the end of the inspection period. So if prior to closing, seller is unable to meet the as-is maintenance requirement as required by paragraph 11, a sum equal to 125% of estimated costs to meet the as-is maintenance requirement shall be escrowed at closing. If the actual costs to meet the as-is maintenance requirement exceed the escrow amount, seller shall pay such actual costs. Any unused portion shall be returned to the seller. This is a situation where the buyer goes through the inspection, they've seen everything, they've asked for repairs, and they go to walk through and maybe there is a leak and they see a mark on the ceiling where the ceiling is now stained from the leak. Maybe there's an active leak. We will have buyers and we will have sellers argue that they don't have to close. The contract says, absolutely, we have to close. We have to get an estimate and we have to escrow 125% of the cost to repair this. Sometimes we have to extend closing to figure that out. Oftentimes we just come to an agreement as to whether or not there's going to be a credit or there's going to be a certain dollar amount held in escrow. I use this section to talk to clients to tell them, in this situation, you don't have a way out of the contract. This is what the contract says. So at the closing table, explaining to everybody what the contract actually says, and then we try to get everybody to come to an agreement and close the transaction. Seller's going to have to deal with the problem anyway if they backed out of the contract and had to deal with a new buyer. The buyer is ready to close. That's something that not a lot of agents know about. So if you have to deal with it, that's what it is. And that's what section 11 with this change is referring to.